Welcome, everyone. We have attendees from around the globe today, which is wonderful to see you all here. I'm Dr. Allison Fiducia, the co-founder of Psychedelic Support and a neuropharmacologist who's been working on researching psychedelic substances for some years now. And each month we host this free webinar to help educate practitioners that are working in the field as well as the general public. And today we are hosting some attorneys that specialize in psychedelic medicine so that we can better understand this emerging landscape of psychedelics and how we can stay safe, reduce harm for ourselves and our clients, and better understand some of the gray areas or new emerging topics that come up. This is actually the third year that we've hosted this legal landscape webinar. And I'm really excited to learn more because each time we've had a lot more questions than we've even been able to cover. And it just highlights the need for these conversations to unfold for the community. Before we get started, I just want to mention that we will record this. We'll make the video available to you through email as well as on our speaker page and YouTube page. So I'll drop the link there in a second. And you're welcome to join our monthly webinars again, or go deeper with our education, or look for a therapist in our directory and community groups there. This being a legal webinar, I'm going to start off by reading a disclaimer, which says that the information provided during the webinar today does not and is not intended to constitute legal advice. Instead, all information made available during this discussion are for general informational purposes only. Given this webinar is taking place on August 16th, 2023, content shared in the recording may not constitute the most up-to-date legal or other information. Individuals watching this webinar should contact their attorney to obtain legal advice with respect to any particular legal matter. No audience member of this webinar should act or refrain from acting on the basis of information on this webinar without first seeking legal advice from counsel and their relative jurisdiction. Only your individual attorney can provide assurances that the information contained herein and your interpretation of it is applicable or appropriate to your particular situation. This webinar or any of the resources mentioned do not create an attorney-client relationship between the viewer and the website authors, contributors, or the contributing law firms. So all very important information to keep in mind. And with that note, I'm going to introduce our moderator today, Adriana Kertzer. She's the co-founder and the attorney working with the Plant Medicine Law Group, which specializes in psychedelic infrastructure dedicated to expanding equitable and legal access for both nonprofits and businesses. And they help to launch, fund, and scale businesses and organizations. So it's a real pleasure to have Adriana here. And she's going to introduce our other panel members here. So do chat, put your name in the chat, say hello. And if you have questions, we do have a Q&A box there. We did gather quite a few questions before this, but nonetheless, we welcome your questions there in the Q&A in the bottom of your dashboard. So welcome, Adriana.
Excellent. Thank you, Allie, so much. Thank you for inviting Plant Medicine Law Group back. We had a great discussion last year. It feels like so much has happened in a year. Thank you also for consolidating the questions received from the audience in advance. We wanted to do that to make sure that we weren't perceived to be giving individuals specific legal advice. So we got those questions, neutralized them a bit, and we'll be sharing answers here. So consider this entire conversation one ginormous Q&A. I'm Adriana Kertzer. I'm originally from São Paulo, Brazil, now a New Yorker. I look like I'm living in a theater set because I'm in Maine right now. And I'm very excited to have a dear friend of the firm, Harry Nelson, here with me, and a member of Plant Medicine Law Group, Deborah, here as well. So without further ado, Harry, could you please introduce yourself to the audience?
Sure. Yeah, thank you so much. Thanks, Adriana. And thank you to both of you and Allison for including me today, again, in this year's edition. Great to be with you. So my name is Harry Nelson. I am the founder of a law firm called Nelson Hardiman, which is specialized in healthcare and life sciences. We're about 25 lawyers. and I've been practicing for about 30 years in the area. My connection to this topic today is really began out of work on DEA compliance, originally in academic medical centers and in clinical research, and increasingly in the 2000s moving over to work on behalf of physician prescribers and researchers, and a lot of history in the early days of cannabis regulatory work when California became the first state to open in the early 2000s. And I teach on this topic in graduate medical education and undergrad courses at USC as well. But really delighted to be with you.
Excellent. And Deborah, welcome.
Hi, good morning. Thank you so much for having me here with you all today. I am a healthcare attorney. I'm licensed in California with 23 years of experience. I spent 14 years as an in-house counsel at a national publicly traded healthcare provider. I handled regulatory issues, quality assurance, the corporate practice of medicine, compliance, risk management, payer and insurance issues, employment concerns, hospital contracts, even marketing. I joined PMLG in December of 2022, and my clients include clinics that are part of phase 3 MDMA trials, an international psychedelic treatment center, ketamine clinics, and mental health practitioners.
Excellent. Thank you very much. And so for the benefit of the audience, I want to paint a couple of big pictures. One of them is to contextualize a little bit the firms here so that you can also locate our advice. Harry Nelson's firm is a healthcare law firm, and Plant Medicine Law Group, if you kind of peel back the curtain and look at our everyday reality, we end up being half a Schedule I law firm and half a healthcare law firm. So the way that psychedelic law is shaking out for our law firm is needing to have awareness in these two industries. So I'm going to set up a little bit the kind of the big picture of where this discussion is living, and then we're going to get right into the questions that we received in advance of the webinar. So right now, 2023, summer of 2023, we're all coming off of the high of PS 2023 in Denver. We've got a lot of activity in terms of decriminalization around the country and legalization. That means very different things for licensed practitioners. We've got a reality now in which we have the first state with an active psilocybin program in the form of Oregon. We've got Colorado soon coming online, which will have its own regulations and differences and similarities to Oregon. This webinar is going to be non-state specific, meaning we are addressing questions that we found relevant to licensed professionals or individuals who want to be facilitators in general. But Ali and I have started already discussing the potential of doing something specific for Oregon and Colorado. We also have legislative activity in different states like California, and different bills being passed and in different, stages of discussion. We've got federal activity also taking place, bipartisan issues to reschedule certain substances, revisit certain conversations about where some of certain psychedelics live in terms of the Controlled Substances Act. And then, of course, we also have larger conversations in the psychedelic community about entheogenic churches. So this webinar won't go into detail about any of those particular areas, but just to kind of paint the broad universe in which this discussion today sits in. So, Harry, can you get us started on, given this big overview that I gave, what are the patchwork of laws and regulations that licensed professionals and future facilitators need to consider when thinking about psychedelics?
Sure. So I would say the first thing that's really important to understand is the way that federal and state law occupy different parts of the relevant legal landscape. So, when it comes to we look to state law first to regulate all professions, right? And that includes all the established licensed healthcare and mental health professions, as well as potentially in new states that are opening up programs like Oregon. What are the rules, the scope of practice, and the things that are permitted to people by virtue of having a license or a registration or certificate in a state. State law also is really important in this area because in addition to regulating the practice of the professions, it regulates, it's the primary regulatory body for illegal substances at the state level, right, which are mainly regulated by local and sometimes state law enforcement at a criminal level in terms of manufacturing, distributing, possessing, and transporting illegal substances. So on top of that, we have this overlay of federal law thanks to the Controlled Substance Act of 1970, which makes most psychedelics, right? Other than, we always have to split this discussion between ketamine, which, because the controlled substance list has Schedule I drugs that are deemed federally to have no medical purpose and therefore to be illegal, and Schedules 2 through 5, which are for drugs that have varying degrees of abuse and risk associated with them. So ketamine is a legal drug on that schedule, right, as a Schedule 3, but all the other drugs that we're typically talking about in this conversation are Schedule 1. So the important thing for practitioners to understand is that you have to be looking at both bodies of law, and generally we have the principle that federal law is supreme. In this area, one of the things that's very important to understand is that, by the way, important to remember, whenever we look at the DEA, the Drug Enforcement Administration, it's within the Department of Justice federally. So they historically were the driver of laws in this area. The significant change that happened around cannabis and the big question facing the psychedelics, the whole area of Schedule I psychedelics is whether that construct will hold, is the law that we've been living under since 2013. And by the way, throughout this discussion, we'll talk about things that are sort of in law, meaning they've been signed into law by the president at a federal level or by a state governor, regulations passed by agencies, and guidelines, like sort of internal documents. And so the key document in this whole area, to this question of how federal and state law interact, is this 2013 memorandum, not a law, not a regulation, by the Department of Justice, by a Deputy Attorney General named Dana Cole. And so what the Cole memorandum said is that even though the federal government has the right to come in and because Schedule I drugs are criminal, to essentially stop states from regulating in this area and permitting medicinal or non-medicinal forms, that there's going to be a voluntary restraint exercised on the part of the federal government under the Cole memo, not to do so unless you run afoul of these identified areas that the federal government's going to keep focusing on, which included activity in states that haven't decriminalized or legalized, activity that goes across states, activity that is believed to involve crimes like money laundering or fraud, activity that involves children, activity that involves federal lands, and activity that's seen as having involvement in organized criminal groups. So we're assuming, for the most part, we haven't seen any indication of whether the Cole memorandum is going to be the law. The good news is that after a period of uncertainty that anyone who lived through the cannabis regulatory evolution saw before 2013, we've had 10 years of a stable policy where it seems that the federal government is going to be hands-off on things that are permitted under state law. And so that's kind of the conversation to sort of set the table about today.
Yeah. Thank you for that. And let's put it into practice and apply it to one question that came in. So it says, I am an LPC in Michigan where psilocybin has been decriminalized. My brother is a physician who owns a wellness center that houses my counseling practice. We are considering taking the center in the direction of a public-facing psychedelic-assisted therapy clinic and would like to hear what liability concerns we face given that state and federal laws are not aligned with our local jurisdiction. So here we have decriminalization, which everyone should know is different from legalization, and putting into practice. So what's the short tidbit advice that you would give this individual?
So it's a great question. By the way, it's very interesting because the note here you mentioned was that it was so first of all, is we have to always ask, is decriminalization happening locally or is it at the state level? Because the regulators of state licenses of state health professions are state, not local.
Right.
But in general, assuming that the state has decriminalized, does give some latitude to health professionals within the scope of their practice. But the important piece I would say here is to distinguish between the sort of protected zone of the health professional patient relationship and free speech, and activity that would actually be seen as, direct involvement with cultivating or distributing or possessing or transporting the drug. And so the key case, by the way, that was really an important moment in and has driven for the last 20 years U.S. law, is a case out of the Ninth Circuit in California called Q&amp v. Walters. And that case was a case where the DEA, the federal government, tried to prosecute a physician who was at that time relying on California's state law to recommend cannabis. And the federal appellate court said, no, DEA, you can't prosecute that doctor. The doctor has a free speech right, very similar to kind of the right of doctors to prescribe off-label, beyond the limits of what the FDA approves. And it said you're interfering with the doctor-patient relationship. And that case was very important because we've seen since then a real clarity that as long as you are not recommending something as long as you as a doctor are recommending something that in your state is permissible, irrespective of what federal law says, the state regulates your license. And so you are permitted to talk about it, recommend it. The place where we saw people get into trouble is where they went beyond that and they actually started, having economic interests as providers, selling it, being very involved in the second piece of it, which is the providing it to patients, and kind of, being involved.
Having an economic, right, having an economic interest in the background. So just to simplify, remember everyone, the difference between state level decriminalizations versus local, and also this idea of recommending versus having economic interests. All right, on to.
Can I have one small point?
Yes.
So when it comes to doctors, we often talk about prescribing and dispensing, right? The core activity of doctors ordinarily is prescribing, meaning like saying a patient has a diagnosis and therefore we're going to say that this is the medication that's appropriate for them, and essentially authorizing the patient to get a drug from a pharmacy. In this area, because of the DEA status, it's recommending. And so the question is really, where's the line go beyond the making this recommendation to a patient and then going beyond? The dispensing activity is not part of the core activity of medicine. That's really a separate activity, pharmacy, and it doesn't. Part of the challenge in the space is until your state creates a pathway for how do patients actually get access, that's a kind of missing piece.
And we'll get to some of that in a little bit. All right, Deborah, this is a question that's super important. And so I'm happy that we're highlighting it first. The word therapist, who can legally use it and when does it have to be avoided?
Yeah, I understand why this is such a confusing question, because therapist is a really broad term. And when we use it casually with each other, it's used very loosely. But when we use it professionally, and I should say marketing it for ourselves professionally, it refers to those who are licensed and credentialed as therapists. And those are licensed clinical social workers, licensed marriage and family therapists, licensed professional clinical counselors, and licensed clinical educational therapists. And the question really should be, who should not market themselves or present themselves professionally as therapists? And those would be those who do not have those professional licenses. And to be clear, if you do present yourself as a therapist professionally, market yourself as a therapist professionally, could be subject to fines and even in some cases arrest. So for example, a lot of people have studied and have degrees in clinical psychology, but they don't actually have a license in clinical psychology. People may have training to provide counseling, but are not technically licensed therapists. And we have seen websites where individuals who do provide counseling services are holding themselves out as therapists and present themselves as therapists, but they're not technically therapists, as I just defined.
Mm-hmm.
So people should be taking precautions about how they represent themselves to the public professionally and especially to their clients. It's in order to protect themselves and their liability, and ultimately it protects their livelihood.
Right.
So while
we at the firm have seen examples of confusion both on the kind of the patient side. So
Right.
reading someone's bio, like you said, that alluded to someone's clinical psychology training, but then that person didn't have licensure, and there was a situation where a patient was very confused because they thought they were going to a certain type of therapist. And we've also dealt with misrepresentation of backgrounds as well.
Right. So, if people have, requisite skills and training, they should be honest and present that instead, represent what particular skills, what particular types of credentialing and training somebody has. Just be honest and upfront about what type of training, but don't, use the specific term therapist.
Right. And in states like Oregon, use the terminology, and soon Colorado, use the terminology that is dictated by the new legislation. So in Oregon, it is facilitator and
Exactly.
not therapist, right?
And there are very specific terms on whatever credentialing or training or education any particular counselor has received. And those are the proper terms to be using on whatever marketing or website a particular counselor or facilitator is can use.
And Harry, can you give us some examples of people that have gotten, how people get in trouble in this terrain?
Sure. Yeah. So just a couple of quick stories. Yeah. I mean, first of all, anytime we've seen lots of cases where somebody referred to themselves, use the term doctor, or I don't remember a specific case with the word therapist, but we've seen where that was used on a website or used in discussions on an office. Here in California, health professionals, by the way, for most professions have to put their name on their like if they're on their clothing, like they have to wear it in a certain size so people can see with their title and what their credential is. It has to be on the wall. So we've seen a number of cases where people have called someone casually the doctor, and that has been the entire basis of a professional disciplinary action. But the case that stands out to me the most on this topic is, goes to an example that Deborah was talking about. We had a psychologist who had a PhD. This person was teaching at a major university and decided to open a coaching practice and calling themselves a life coach, right? Which is I think the coaching and therapy are very, very similar kinds of things. And so the problem was that she was obviously a very highly trained psychologist. She was treating serious trauma, which is not what life coaching is, right? Life coaching has this kind of narrow zone, just as an example, of helping people set goals and be better communicators, but not getting involved with trauma and not using psychotherapeutic technique. Anyway, the psychologist was, in the course of these interactions, basically opening the client's eyes to issues coming up with the father. The father made a report and a false report about the provider and said, "Oh, this person's giving my daughter medications." It was totally false. But the key point here is that as soon as the licensing board found out that this person without a license was holding themselves out and engaged in this activity, even though they were using this life coach title, they literally had somebody go in undercover as a client, confirmed that they were getting involved in issues of trauma, and the second visit, when the psychologist thought they were opening the door to the patient, 5 flak-jacketed police officers came in, and the person was handcuffed on the ground and was criminally charged. So I just use that case as a sort of extreme example of, if you are not clear about what your role is, and if you use ambiguous language that leads people to think you're one thing or the other, or if you actually get involved in doing things that really require a license, you're no longer under this. You're not somebody who a licensing board is going to look at. you are now someone who's facing potential criminal risk, because there is not, essentially the licensing boards only deal with their licensees, and you are kind of floating out there at risk of a prosecutor or law enforcement who decide to make an example of you.
Right. Wow, that got dark real fast. but
Sorry,
no, but real examples are important, and we're not here to fearmonger, but I did want to pull in examples because I know that your firm handles when these things kind of go wrong. Another important thing to say at this point in the webinar is that we at Plant Medicine Law Group recognize that we stand on the shoulders of giants, that there were people that came before us. There's important knowledge that has been developed in the psychedelic underground that enables what many people now call the psychedelic renaissance. So it's important for us to take a minute and recognize, amidst this legal conversation that also takes place in a moment in which things are changing, to take a moment to acknowledge that knowledge has existed in indigenous communities and has been developed in the underground that we now all benefit and that clinical trials draw upon. So just to say that before introducing the next question to Deborah, which is, Deborah, someone asked, should licensed professionals or can licensed professionals refer clients to underground practitioners?
In order to protect your license, no. We need to keep things above ground legally. Until the substances are legalized, you can lose your license. But there are jurisdictions where certain medicines are legal. And depending on how you word your advice to your clients, there are retreats in jurisdictions such as Jamaica that offer reputable therapeutic experiences that can be of great benefit to your clients. And until these substances are legalized, that's what you should stick to in your practice.
Right. So many of the attendees here today, I think we have about 200 people listening. Many individuals here are licensed and are in touch or aware of underground options. And I think the discussion here really is focusing on what should you do with that knowledge and those relationships when working with patients. And again, this tension between, what we know exists in the underground and what we can work with is very real to us at the firm every day. So Harry, a question came in that asks, what are the risks that psychologists face who offer harm reduction and integration? How can these risks be mitigated? In other words, how can people legally offer psychedelic integration practices in states where entheogens are not legal? And so if we slice and dice a process, preparation, the actual guided experience or trip sitting kind of phase of the experience, and then integration, right? And if we say that harm reduction can, for example, take place in the preparatory phase, can you address this question?
Yeah, it's a great question. It's a hard question, but just a couple of thoughts. First, I think one thing that's really important to recognize is that this question kind of has evolved over time, right? Just from the example I gave of the Q&amp v. Walters case, in the early 2000s, we were seeing the federal government prosecuting physicians for what they were talking about, and now we know that as of 20 years ago, they can't do that anymore. And there's been a shift, and what I can tell you that what we've seen is that it's happening gradually, so that as social attitudes move, right, regulatory attitudes are also shifting as to what's appropriate. So in the harm reduction example, if we look at like opioid related medications, just to use that as a sort of contrast, we see that there's a much greater latitude to make recommendations to patients because harm reduction is getting more and more accepted in that arena. But there are limits, right? There are doctors out there, for example, who say we should be having a completely unrestricted prescription and dispensation of narcotic opioid, pain medications because those are safer than the fentanyl in the streets. And the people who are saying that are kind of one step, beyond where the social conversation is today. I think you have to be careful about, the sort of where we are, and in particular in your state where we are, because I think some states, we're seeing states that clearly have moved to a place of recognizing that these things are being used and are more tolerant, and states where there's a lower threshold. So I think it's very important to look to your jurisdiction. But in general, I think that there is some latitude, as long as you are not directly involved in the procurement of the product, and you're really just helping people who are thinking about doing something and not actually enabling them, whether you're talking to them before or in an integration phase after. My view is that that is still within a protected zone of activity, subject to sort of making sure that your state is not taking a more aggressive approach to psychedelics in general.
That's really interesting. So the same advice that would be given by a psychologist in California, right, to someone who says in their appointment says, I will be taking, LSD, and the list of medications that I'm on, what should I be worried about? That conversation could be treated very differently in a state like Georgia, where, for example, even attorneys are not allowed to counsel cannabis companies. So it's like, the culture of the state is so not all advice by all psychologists around the United States is going to be treated similarly. And I like that you highlighted not enabling, not procuring. So yes, some gray area there. And I like the state specific angle to it. We then got a bunch of questions about insurance, which I will delight in covering. So in general, many different questions about insurance were, how can I get coverage? I'm in Oregon, there's no coverage. I'm in Colorado, how will I get coverage? Or MDMA, when it rolls out, what's going to happen? And so this is not a commercial plug, it's more of a PSA because I think it's helpful. But September 1st, the first product of its kind, to my knowledge, will go live, and it's called TheraCover, and it's a direct-to-consumer medical malpractice insurance product. So theracover.com. You might have also seen their booth in Denver at PS 2023. And so direct-to-consumer means you do not have to go through an insurance broker to secure it. And this product will cover 3 therapeutics. So ketamine, but not telehealth. Psilocybin in states where it is legal. So that includes service centers and facilitators, which to date have had a very, 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 very tough time securing insurance coverage. And then once MDMA becomes legal, or approved by the FDA, then this insurance will cover it. So some of the gaps in coverage that our clients have been dealing with will probably be covered. So Oregon now, Colorado coming up. Here's a question that came in that I ran by my insurance broker. So it says, I'm a licensed psychologist in California. Should I inform my insurance company that I'm adding ketamine preparation, sitting, and integration to my professional repertoire? I'll be working as a contracting clinical psychologist with a reputable ketamine clinic in California. There is nothing in my insurance renewal statement that asks about ketamine. And because it is a legal treatment, I'm assuming I can go about my professional duties with the same coverage as I would otherwise get. Do you think any other actions would be prudent? I'd prefer not to call something to their attention that they may decline to cover preemptively if it would otherwise be covered. Now, I had a gut feeling of what I thought my answer should be to that, but I called on my broker, and his advice was, I think, spot on. I believe it's better to be safe than sorry. I would hate for there to be a claim and have that carrier be able to disclaim coverage because of a material withholding of information. While sharing this information might result in needing a new carrier and potentially a higher premium, it is what I would suggest. So in other words, not sharing information about this new direction in a medical practice is probably not a good option, because if something does go wrong, and God forbid you might be sued, the entire situation might come as a surprise to you as not being covered. So yes, it might mean a higher premium if you are dealing with psychedelics during this season where insurance companies are getting used to what this means, the government is getting used to what this means, but it is prudent to disclose and have that conversation up front with your broker. All right, here's another question. Is ketamine for mental health reasons ever covered by insurance? Is it always considered off-label use and therefore not covered by insurance? And so I double-checked this, and according to our broker, some carriers cover it. So Kaiser in California and Blue Cross Blue Shield in places like Utah cover it on an individual basis if you submit a claim and appeal. So it's interesting that they're adding kind of like that additional barrier. But yes, in general, at this point, summer of 2023, most people are paying for ketamine when used off-label, which is for mental health reasons, out of pocket. Harry, what will the insurance reality look like if MDMA or psilocybin gets approved? That was another question that we got.
So well, there's two different things to talk about. In general, look, the insurance companies are, not to be cynical, but are somewhat opportunistic in terms of finding reasons not to cover different therapies. And so we've seen this point has been a real struggle for ketamine. We are seeing some slow progress, but frankly, we've seen a number of businesses where there was demand for ketamine, but there wasn't enough to support the cost of it without insurance. And so, if drugs are legalized, decriminalized at the state level, generally we have not been seeing insurance companies moved by that. We have seen, if there is a Schedule I move, right, to make drugs like MDMA a Schedule II or lower, meaning a drug that could be prescribable, then I think that will begin. That'll be the beginning of a change, right? It will essentially begin that process of the coding opening up and the sort of leading organizations, professional organizations supporting the legitimacy of the therapy and sort of forcing the insurance company's hand. But I expect the insurance companies to kind of go kicking and screaming into the reimbursable era, and I wouldn't be sort of setting a hard timeline for when that's going to happen.
Right. So we did see recently the AMA, the American Medical Association, publishing new CPT codes, which was a joint effort by MAPS, PBC, and Compass Pathways to start creating this reality of codes that could be written down for a longer period of therapy, but it will be company by company. You said, right, Harry, plan by plan, slow rollout of individual companies agreeing to this.
Yeah, and we've definitely seen that the payers are going to go slowly, and it's going to be payer by payer. But I think that development you're talking about the coding being available is a major sign. I mean, that's the sign of essentially that the AMA is essentially agreeing with the view that these should be more broadly available and reimbursable, and hopefully that kind of pressure will lead to a change.
And just a reminder to everyone here listening to the podcast, and Deborah and Harry, feel free to push back, but just to clarify that when we say MDMA becoming legal through the FDA or psilocybin becoming legal through the FDA, what will be rescheduled are the specific compounds that have gone through the clinical trials. So it's not just any MDMA, it will be the MAPS MDMA. It's not just any psilocybin mushroom, it will be the synthetic psilocybin compound pushed through clinical trials by Compass. So just to kind of flag that so that when we in this discussion talk about MDMA and psilocybin FDA, it's not going to be the whole universe of that chemical compound. It'll be that specific compound that went through the clinical trial. So speaking of the plethora of psychedelics that exist, Deborah, question came in. Can providers share their personal experiences with psychedelics in their therapeutic relationships with patients, or, you know, with patients in general?
This is an area where I would recommend treading lightly. You know, there's a lot of psychedelic exceptionalism right now. And we're all really excited about the benefits of the work and want to help people. But it doesn't change the rules of ethics or the professional and fiduciary responsibilities that mental health professionals have to their clients. And we know that there are the issues of self-disclosure in therapy, and those issues are ones of boundaries. And we're working to grow this field into psychedelics, and we want to do it responsibly, and we want to do it with integrity. And part of that is developing and maintaining the same boundaries that you would set otherwise in your practice. So I think it's really crucial that we find the right phrasing to maintain that profession or your professionalism at all times. So in doing that, I would consider that you would be keeping yourself out of hot water should anything ever go wrong with your client outside of the office in the medicine as well. So just things to think about.
Excellent. And by psychedelic exceptionalism, you mean, for example, you know, this understanding that, you know, what a doctor would say, for example, about their Prozac, would or would not say about their Prozac need, right, is kind of like, let's not think of psychedelics so differently from the standards and the ethics that we would apply to Prozac or, you know, some other medication. Let's try to think of the advice or the experiences along the continuum and not an exceptional category. So Harry, I want to turn this conversation in the direction of non-licensed individuals. There are several psychedelic coaches and facilitators who do not have licenses, like LCSW, LMFT, and so on. Some individuals have completed a certification or a weekend intensive and then take the liberty of calling themselves therapists or performing psychedelic therapy. Again, we get back to that word. What legal liability does a facilitator like this, who claims to be a therapist but does not hold state licensure, face?
Yeah, so it's you know, it kind of ties into what we were talking about a couple minutes ago, about, you know, that there clearly is, if we're talking now, assuming that you're in a state that hasn't created a construct for, and you're just holding yourself out as a psychedelic therapist in a state that hasn't defined or approved anything like that. And I think it's a risk, right? Like what happens essentially is, you know, and this is different state to state, but you have these state licensing boards, particularly mental health professional boards, that are kind of watching, and they're more worried about, are you stepping on the toes of people in the licensed professions? But they are paying attention, and it's very clear. It's certainly in the larger, more activist states that have more active licensing bodies. They're paying a lot of attention to who's saying what, and when they see people who are unlicensed, since they don't regulate those people, they don't have a license that can be sanctioned or revoked. They refer them to law enforcement. And so the question is, you know, are you may be, as an unlicensed person, if you're not careful about what you're doing, you're at risk of kind of falling into that zone. So generally, you know, my advice for people in that sphere is, it's very important to sort of, you know, make it clear that you're talking about, you know, that you're staying in the category of education, and really to make it clear that you're not engaged in a profession. It's very important to understand where the lines are between practicing a profession as a therapist and not being ambiguous, right? And when you're merely doing education, providing information, and I think there is a reasonable range of things you can talk about, but you have to be very careful. And I think it's very important in all the ways you communicate on your website, in your the documents that you ask patients to sign, to make clear what the relationship's going to be, and then what you actually do to sort of stay within those limits if you're in that unlicensed category, because in some ways you are the most at risk, given that you're not operating within a licensed construct that states have a framework for.
Right. So speaking of states that have a framework, I want to flag for everyone here that in states like Oregon and Colorado and others, right, hopefully, these states are creating programs with requirements. So if you are a psychedelic coach or guide and you're in those states and you want to, be above ground, you will have to start tracking what requirements those states will have for you to have whatever license, right, or whatever is required for you to operate above ground. And so one thing to flag here is that, for example, in Oregon, you have to have licensure in a certain number of hours, and then you also have to make sure that you studied in a school that has a certain level of state accreditation. So we know that in the psychedelic space, every day you see a new school pop up, or a new online course, or a new weekend long intensive. As laws change state by state, we will see requirements on what school or what education is sufficient for the next step. So assume that, well, unfortunately, if you have been educated in a certain place, you can't assume that that will be deemed sufficient by a state that legalizes going forward. So not all schools offering psychedelic courses are accredited, and not all of them will be deemed sufficient by states that legalize. So, Deborah, question came in. What is the problem with using MDMA for PTSD now?
Well, it's still not legal. And as we just discussed, we don't even know when it is legal, how and in what form it even will be legal. But we know that this is really exciting, and the research is being shared and the work is good. But and we know that people are doing it underground, but unless you as a practitioner are part of a trial and your client is part of a trial, it is still illegal. So you could lose your license and you could go to jail. So that's why.
Right. And Harry, is there any value in having clients sign a waiver or disclaimer if trip sitting is taking place in a region of the country where entheogens have not been decriminalized? So there are many things in this question, but is there, if you are engaging in an activity which involves trip sitting and you give someone, a package of documents to sign, what value is there in that?
So yeah, I would say I think there is some value, but we just have to understand the limits of it. So I think I always think it's useful to kind of reverse engineer from what's the risk you're facing, right? One risk is that the person who you're working with or their family, if there's a bad experience or God forbid a harm event, you could be facing a claim from that person. And then of course there's what the government, what government regulators or law enforcement might say about it. So I personally believe that we're living in a time when it's very helpful to clarify in your documentation both about the overall relationship that you're establishing at the very beginning with a client and in a particular experience or treatment or segment of your work with them, to be really clear and say, here is what I do, here's what I don't do, and to say there are other people out there who have other views of this, right? So to me, it goes back to the concept of informed consent. Really starts with what are the risks of this activity? What are the benefits? That's the least important piece to share with people. And what are the alternatives? And I think it's very important if you're doing things that are non-traditional to make sure that you say those to people so that no one can say that they sort of were, they didn't understand that you were kind of taking them down a pathway that might not be what other, the most conservative or traditional pathway. So so I think there's an inherent value in putting those disclaimers out there and getting people to acknowledge the risks and make it clear they want to go forward and knowing all those risks and alternatives. That said, I think there's a limit to how valuable these documents are when you get into things that are just not legal, because there's a limit essentially in the law to what people can consent to. And so these aren't perfect, but I still think it's much better because it really establishes that whether you're talking about trip sitting or integration or whatever activity you're doing, what are the limits of what you're doing, and those documents, to the extent that you live within them, and you never want to be in a case where the documents say one thing and the stuff, what actually happened on the ground, looks very different, because then it becomes used against you. But as long as the document matches up with how you actually behave, I personally believe that those can be very helpful, certainly if you're dealing with families, but also in many situations with helping law enforcement see that you were really trying to do your best in a complicated area.
Very nuanced advice that I'm sure will be appreciated by many in the audience of this webinar. Deborah, here's another question. I'm a licensed mental health provider. Can I reduce my liability by offering coaching or faith-based religious services?
It's a good question. It's sort of a two-part question. Whether offering coaching to reduce liability or offering religious faith-based counseling to reduce liability.
Which one of Harry's examples was
I think Harry gave a really good example regarding the coaching. So yeah, I mean, with respect to the coaching, I mean, technically, yes, but obviously in light of Harry's explanation of what can go wrong, I really wouldn't recommend it. Coaching is an entirely different line of work from being a licensed mental health professional. As Harry pointed out, it doesn't require a license. It doesn't require specific education or experience. Coaching is a really broadly defined type of counseling. There are no laws regarding confidentiality. There are malpractice insurance policies that can cover coaching, but those are entirely separate from what you would have as a licensed mental health professional. And your coaching practice would have to be entirely separate from a mental health practice. You would have to have separate website, separate name, separate business cards, letterhead, everything would have to be separate. But also you'd have to consider, most importantly, how your clients would think of you. You would need to consider the rules of ethics governing mental health practitioners. And again, what can go wrong? And you would have to set clear boundaries, be very clear with the clients, so that they understand the differences between coaching and psychotherapy. And as Harry again pointed out, it's a really difficult line to walk, and I'm not so sure I would recommend walking that line, given the potential for liability. And then with respect to religious counseling to reduce liability, I don't think the question has to do with practicing as an entheogenic church, because that's a completely separate area of the law, which is obviously gaining a lot of popularity. I think the question is whether you can offer faith-based counseling as an alternative to mental health services to reduce liability. The answer is not so clear-cut, because religious services can include Christian counseling, biblical counseling, or counseling as a pastoral counselor, which is like a chaplain. As far as Christian counseling, that's really no different than being a mental health practitioner. It's just more of adopting a worldview within your own practice. So everything is still the same. You just have a more of a religious-based practice. With respect to biblical counselors, there's still a certification that needs to be completed, but your counseling is subject to a particular church's rules, and there's no state license board overseeing your practice. So I can't really speak to liability because it would be up to a particular church. As for pastoral services, those are usually clergy or lay people who can provide counseling services, but on behalf of a church or a place of worship. So it may limit liability, but it would be in the hands of the place of worship, and it would change the trajectory of the mental health services that are being provided because they would be on behalf of the place of worship. So it could limit liability, but again, it sort of changes the services that are being provided. So
Wow,
if it is,
thank you for that. Thank you for going in the very specific direction that broader question. So I think that one of the big takeaways from this discussion is whenever you think you're opening a trapdoor to liability, right? Not disclosing something to an insurance company, kind of trying to be one thing in order to not be beholden to the rules of another, probably not a good idea, because it doesn't necessarily save you from liability. So we have 4 minutes left. I want to ask one last question of Harry and then ask Allie if there's any pressing hot questions. I know there's been a lot of activity in the chat that I haven't been able to look at while hosting. So Harry, before I toss it to Allie, this all is probably very overwhelming to people. How can they track changing laws in their states and keep up with, what they can and cannot do?
So it's a good question. I think, the important thing I would just emphasize is there's a lot of resources out there. You always, whenever you're looking at anything online, you want to ask the question, am I looking at a primary resource or a secondary resource? And what I mean by that is, when you go, if you are looking at something and you can see that it is the legal code of whatever state you live in, and that you are reading straight from the laws, and I want to come back to looking at laws, regulations, and guidance in just a second. But when that's very different than when you're reading an article that a law firm wrote or that somebody wrote, or by the way, lately I've been out of curiosity, I've been using ChatGPT and Google Bard and saying, hey, what do you think of this? And I can tell you that as a lawyer, like most of the time when I ask hard legal questions, I get the wrong answer from them, right? And they're not holding themselves out as being accurate, but you get a lot of inaccurate stuff in the secondary literature. So I'd say to people, look at the primary sources. It's very, and I would say it's important to track what are actually the laws in that state, what are the regulations, and then there's this whole area of guidance that's very, very important, right? That will tell you how the different state regulatory agencies, and you have to look in multiple places, right? How are the mental health boards? How's the medical board in that state? How is the attorney general, right, as the state sort of criminal law enforcement agency? How are they interpreting the law of that state? What's their policy? And that's the most useful way. A lot of times when we don't have those clear statements, then we start looking to cases and talking to people. Although you can never rely entirely on what someone tells you, even if that person is a prosecutor or someone in a regulatory agency. They can tell you things. It may be really helpful, but you can't completely rely upon it. So you want to be tracking this stuff as clearly as possible through primary sources, my recommendation is that it's much easier to get information from a lot of places, but you always need to really track it down, and you want to always start with the broad information that you found in that article, but then track it back and make sure that you can actually find what exactly that person's pointing to, because you won't be able to take a piece of paper and say, look, here's the article I found on Google, if you run into a problem. On the other hand, if it says it in the law, it's worth making sure you're understanding it correctly, talking to lawyers, and colleagues, but that's generally the process that I would recommend people go through.
Fascinating. Fascinating. I won't even say, hire your own lawyer. I'm not even going to say that. Allie, before we wrap up, I know we're at the top of the hour. Anything that you want us to address?
There are so many questions that have come through the chat in the QA. I think it just really highlights the need to have experts like yourself come on and educate us about legal matters. I know myself, this feels overwhelming a lot of times. I just want to stick my head in the sand and not pay attention. But it's so important, and investing the time, energy, and resources to prepare yourself, reduce risk, and not end up in these sticky situations is really good advice that you all are bringing forth here. So instead of posing another question, I'll just propose that we do this again. And I'll save all the questions and go through the chats, and we'll continue to address everyone's questions the best we can. And just host this webinar and this informational session again with you all would be
excellent. So save those questions. As everyone has seen, we like curating the questions, doing additional research where necessary, finding who among us wants to answer a particular question. But yes, and just, we are living in interesting times. We at Plant Medicine Law Group have received, have been contacted by individuals that are now going in front of their board because they've decided, because they decided to administer psychedelics, before certain permissions came out. People made complaints to the boards. We know that these stories are already starting to unfold. We know that psychedelic use is being brought into custody disputes following divorces. So it's just like we see the risks of doing certain things in our day-to-day, and obviously Harry does as well. And so, we're not having these conversations as fear-mongering. We're really having them from a place of, we believe in these medicines, we believe in these substances. How can we help people navigate this changing landscape and developing laws? So thank you very much, Allie, for having us.
Yeah, well, thank you all so much for being here, to our panelists and attendees for taking the time. I sure learned a lot, and we will share the video after and some of the links and resources that were mentioned here.
Thank you.
Thank you.
Thanks, everyone. Have a great day.